he's facing him. He'd be checking his left eye. And as he's coming in front of the camera, he's not keeping the eye at distinct and sustained nystagmus from maximum deviation for the required amount of time to establish that or verify that as a clue. It needs to be done for a minimum of 4 seconds, and he's much closer to 2 seconds. And then for an onset of nystagmus prior to 45 degrees, as you're moving from center out, you need to, once you observe that onset angle, stop for a minimum of a second and verify that it's there. And you can see that he never does that. So you wouldn't be able to really count those sections as clues because you didn't perform it the right way and you didn't check for it. You didn't go for a minimum.
On November 20th, 2025, Colorado State Trooper Nathan Corey pulled over an elderly man on Highway 115. It was raining. The roads were dark and wet. The man was driving below the speed limit, because that is what you do when the roads are not safe. The trooper decided that was reason enough. He pulled the man out of his car, a man who cannot walk without a cane, and told him to take a sobriety test. Then he made a choice that would end his own case. He decided the eye test alone was enough to arrest him. He ran it once. He scored it perfect, 6 out of 6. And he put an old man in handcuffs on the side of a wet road. There was just one thing the trooper forgot. His body cam was recording, and it caught him rushing the one test his entire case depended on. He could not even perform it correctly. Charles Reed was charged with driving under the influence. Trooper Corey took the stand to defend the arrest, and the defense brought in an expert, Jason Chilson, a former officer with over 1,200 DUI arrests of his own. He pulled up the trooper's body cam and took the arrest apart, frame by frame. What you are about to watch is a trooper who arrested a careful old man on a rainy night, and the expert who proved he never had a case at all.
Test, test, test. Can you hear me? Okay. All right. So this is 25T664. Mr. Reed appears in person with Mr. Selleck. We do have Mr. Tommy here for the people, and we're scheduled for a motions hearing. And Mr. Tommy's just getting set up here. And are the parties ready to proceed to hearing?
Yes.
Are you ready to proceed to hearing?
I think so, Judge.
Okay.
I've got one trooper here and I got one trooper upstairs and preliminary, but they're both here.
All right.
We'd call Trooper Corey.
Come on up here and I will swear you in. Do you solemnly swear or affirm under penalty of perjury the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth? All right, you may be seated. And Mr. Tommy, when you're ready.
Trooper, would you state your name for the court, please?
Trooper Nathan Corey.
And how are you employed?
Colorado State Patrol.
Certified peace officer?
Yes.
How long?
Not with the State Patrol, but in total 8 years.
And where'd you work before the State Patrol?
Western County Sheriff's Office.
And I want to go back to November, I believe, 20th, 2025. Were you on patrol that day?
I was.
And did you have the occasion to become involved in a DUI investigation on Charles Reed?
Yes.
Could you tell the court how that came about and how you became involved?
Trooper Hadley Lamro observed a slow-moving vehicle impeding traffic traveling northbound on Highway 115. I was traveling towards Highway 115 on Highway 50.
So once you got to the place where Trooper Lamro had Mr. Reed stopped, what happened?
Trooper Lamro was getting off duty, and we elected to basically have me investigate the rest of the investigation. When I got on scene, he did advise me he had some observations of impairment as well as an odor of alcohol.
And did he stay around or did he go on off duty at that point?
I don't recall.
You just took over the investigation.
Correct.
So what all did you do?
When I got up to the vehicle, I also detected an odor of alcohol. And then I asked Mr. Reed to exit the vehicle. He was unsteady on his feet. I wasn't sure if that could just be age or impairment. But we moved to the back of his vehicle where we continued in a DUI investigation.
Was he cooperative?
Yes.
And you said he seemed unsteady.
Yes.
But you said that could have been to age and not necessarily alcohol. It just was unsteady.
Correct. I observed the unsteadiness, but I had no idea what it was related to.
And so once you got into the back of the vehicle, what happened?
We had a conversation. He told me that his last drink was approximately 30 minutes ago. He recently ate at Carl's Jr. He had been drinking all day, and he had about 4 beers during the entire day.
And how did you proceed after he told you your story?
I asked him if he wanted to perform voluntary roadside tests. He agreed. Based on older age, I did not perform any walking or standing tests. I just wanted to perform the eye test for nystagmus.
And you're certified in the horizontal gaze nystagmus test?
For SFSTs and ARAD, yes.
So you did the test, and then what happened?
During horizontal gaze nystagmus, I observed 6 out of 6 clues.
6 out of 6, a perfect score. Every possible sign of impairment. The trooper says it like it settles the case. But here is the thing about the eye test. It is the one test where everything depends on how the officer moves his hand, how fast, how long he holds it, whether he follows the timing he was trained on. Do it right and the clues mean something. Rush it and you can score anyone 6 out of 6. The trooper wrote down a perfect score. His body cam recorded exactly how he got it, and an expert is about to play it back second by second.
And what are those clues?
Those clues would be some observations that are not clues. I don't know if you want those or not, but strictly just the clues would be a lack of smooth pursuit, a clue for each eye, distinct and sustained nystagmus at maximum deviation, 1 in each eye, and onset of nystagmus prior to 45 degrees, 1 in each eye.
And you said there were other observations outside those of the horizontal gaze nystagmus. What was that?
We check for equal pupil size and equal tracking, as well as resting nystagmus. We also check for vertical gaze nystagmus, which is not in and of itself a clue.
And once you finished all that, what did you do?
Based on everything, I elected to place Mr. Reed under arrest for DUI.
Now, did you do a voluntary portable breath test with Mr. Reed, or do you remember?
I was advised I needed to be here an hour ago, and so I haven't had much preparation time. I think I did do a portable breath test. I don't remember the results. I'd have to refer to my report for that exact number.
Yeah, I know we kind of got mixed up on this today, and sorry about that. It seems like it's kind of been one of those weeks already, and just for now Wednesday afternoon. So when you ask somebody to do a portable breath test, what do you do?
I advise them it's voluntary, and I usually would explain that I'm trying to confirm my observations.
Was he cooperative with that?
Yes.
And once you arrested him for DUI at that time, did you read the rules about taking a test?
Express consent law.
Thank you.
Yeah. Yeah, he would have been advised of that and then transported to Fremont jail.
Do you remember if he chose, which one he chose?
Breath.
Do you remember what the number was?
I don't. I believe it was a 0.07 something.
So it was below a 0.08.
Correct.
And then that's when you took him to Well, you took him to the jail or?
We transported to the jail simply for the breath test. My sergeant did give us permission to release him on a summons to a sober party.
So he was not booked in and
Correct.
anything of that nature. All right. Thank you, Trooper Corey.
Chuck, are you okay? Are you following along?
Yes, I can.
Are you using this or?
I got hearing aids, so I can.
Okay, so you're okay without that? You can hear everything? Okay. Just wanted to make sure. I don't know if you remember times, and if we can go back to your report. Do you have a copy of your report with you?
Only digitally.
Okay. I want to talk about timelines here. So you got a call from Trooper Lamro at 5:11 p.m. 17-11 hours?
I couldn't confirm that just because I don't.
Because you don't remember?
Correct.
Okay. Would it refresh your memory to look at your report?
Yes.
Okay. If I may approach.
Any objection?
No, Your Honor.
You may.
Well, I can. What about your body cam?
I haven't had time to review the body cam specifically, so I don't know what times that would show on there.
Okay. I didn't have the CAD right at my fingertips, but I might be able to bring it up here for you fairly quickly. Maybe we should just dive into that issue of the body cam. Just a moment. Okay.
Mr. Tommy, do you want to sit here while that's right there? You don't have to. I'm just.
Yeah.
And Mr. Reed? Mr. Reed, do you want to move so that you can see that? You don't have to, but if you want to.
I think I can see.
You can see it. Okay.
Okay. So Trooper Corey, I want to play just a little bit of this to see if you recognize it and can relate it to this particular contact. So I'm going to just hit play here right from the beginning. Just to make note of this, in the upper right-hand corner, it has the time, correct?
Correct.
And do you see it says 17:16?
Yes.
Okay. Is this your body cam from this particular contact?
It is.
Okay. And again, just for the record, this begins at 17:16, which would be 5:16 p.m., right?
Correct.
Okay. Now, I want to pull up a different clip. Okay. Before I go any further, do you recognize the person there in the video?
Yes.
Who is that?
Charles Reed.
Okay.
Yeah. Thank you. So sorry, before we move into this, Mr. Reed, it sounds like maybe you're humming.
Chuck, she says that you're humming. You're making some sounds.
Okay.
We just want to make sure you're listening, that you're okay, and that you're following along.
I'm sorry.
That's okay. So just judges just checking in.
Would you be willing to do some voluntary roadside tests for me to make sure you're safe to drive tonight? Basically what that is all I would do is check your eyes. Okay, you wouldn't have to walk, you wouldn't have to do any walking or balancing tests.
Use a cane. So.
Okay, yeah, I'm not going to have you do any of that. But I just want to check your eyes, all right? Okay. So what I'll have you do is just stand over here and face me this way. Or do you need to hang on my truck? I'm trying to get a knee trouble. Okay. Do you want to drop your tailgate and lean against that? Is it because your truck's locked? Is your truck locked? Or oh, okay. Yeah, you can lean against that. That's fine. Okay. Can you tilt your hat up just a little bit? All right. Can you see the red tip of my pen here? Mm-hmm. Can you follow the tip of my pen with your eyes and your eyes only? Don't move your head. You understand? Mm-hmm. Okay. Yeah, so you're going to follow this with your eyes and just keep your head still, okay? All right, I appreciate it. Can I offer you a portable breath test? It just makes sure that I know that you're safe to drive home.
Listen to that line again. Can I offer you a breath test? It makes sure I know you are safe to drive home. It sounds like kindness. It sounds like an officer looking out for a tired old man on a rainy night. But that is not what it is. Colorado law says before this test, the officer must tell the driver one thing: you have the right to refuse. This trooper never said it. He wrapped the test in a favor instead. An elderly man with a cane hears, "I want to make sure you're safe to drive home," and thinks the officer is helping him. He does not hear a choice. He does not know he can say no. That is not an advisement. That is a trap dressed up as concern. And every word of it was caught on the trooper's own body cam.
So, Trooper Corey, in terms of SFST, standardized field sobriety test, that's the only one you did involving Mr. Reed, which would be HGN, right?
Yes.
Okay. And you testified that you saw 6 out of 6 on that test?
Yes.
Okay. According to your report, he could smell an odor. And the odor was coming from the vehicle, correct?
Yes.
Okay. And what we saw was kind of the substance of what Mr. Reed told you. Is that fair to say?
Can you clarify?
Well, what we saw was a discussion of the alcohol that he'd had consumed during the course of that day, right?
Correct. Yeah.
Okay. So there was no discussion necessarily that focused on what he had just prior to driving.
We just clarified that all he drank that day was beers.
Okay.
Yeah.
And what he said was during the course of that day, he'd had, and it kind of varied, but 2, 3, or 4, maybe 4, I think he said.
Yes.
Okay. Did you remember him saying that on body cam?
I remember it in my report.
Okay. We just saw the body cam, so I guess it shows what it shows. But there was no other conversation about that, like other than what we just watched, right?
That's right.
Okay. So in terms of the really important observations that you made and what your investigation was, basically it's that conversation and the HGN, right?
Correct.
Okay. No further questions.
Good afternoon. Come on up here and I will swear you in. Do you solemnly swear or affirm under penalty of perjury the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth? All right, you may be seated when you're ready.
Thank you, Judge. Trooper, would you state your name for the court, please?
Trooper Lamro, Colorado State Patrol, IBM 0353, Colorado State Patrol.
Certified peace officer?
Yes.
How long?
Approximately 3.5, 4 years.
And that's all with the State Patrol?
Yes.
And what are your duties and responsibilities?
Perform traffic stops, investigate crashes, DUIs, impairment, speed enforcement.
I'm going to go back to, I believe, November 20th last year at about 5 p.m., somewhere along that time. Did you have an occasion to stop at Charles Reed?
Yes.
Did you tell the court how that happened and what you did?
I was traveling northbound in Fremont County, state of Colorado on Highway 115 about approximately mile marker 13. I observed a blue Ford F-150 approximately 4 to 5 cars ahead of me that was traveling northbound at approximately 35 miles an hour in a 50 mile an hour zone. I noted there was approximately 3 to 4 cars behind me for what I thought. I figured it was about 10. The vehicle was driving slow, like I said, doing the 35 miles an hour in the 50 mile an hour zone. As we approached the roundabout, a few cars turned and went east on Highway 50. I believe 3 of them continued north, where I caught up to the vehicle, activated my lights. The vehicle, which was the blue Ford F-150, pulled to the right shoulder, took an extended amount of time to stop. At that point, I exited my patrol vehicle, walked up to the driver's side, spoke with the driver, asked him for the reason for the stop, asked him where he was coming from. He said he was...
Just to back up a little bit, you went up to the driver's side. The person you stopped, do you see here in the courtroom today?
I do. Identify him sitting on the left, wearing a kind of a tan brown shirt, polo, I believe a cowboy hat.
And you contacted him, and what happened?
So I contacted him, asked him where he was coming from. He said he was coming from Florence, from the grocery store. I asked him if he'd had anything to drink today. He said that he had a beer a couple hours prior. And then after that, I asked him if he felt like he was safe to be driving. He said yes. I asked him on a scale of 1 to 10, 1 being not intoxicated, 10 being the most intoxicated, where he would be at. The first response was that he lived just right there, or something to that effect. And then I asked him the same question again, and he replied with 1. At that point, I contacted Trooper Corey to come and take over the stop. After Trooper Corey arrived, I became the cover unit at that point, and I didn't directly observe Trooper Corey's roadsides.
You just were just kind of covering him, making sure everything was okay.
Correct.
I want to go back to the beginning of this. So you were actually in the line of all the cars.
Yes.
How long have you been behind the blue Ford?
Since Florence, so about mile marker 10-ish.
So for about 3 miles.
Roughly. I can't remember exactly how far it was, but about that far.
And I guess you just got in line, and what drew your attention to all that?
The vehicle was just driving abnormally slow for the area. It's a 50-mile-an-hour zone, and when cars start to back up, it was just odd, and that's what caught my attention. As to never seen a vehicle drive that slow unless it's a semi or something like that. So it was a very odd occasion, and he was impeding the normal flow of traffic, which most vehicles go through there at least 45, I would say.
After a bit, it just finally dawned on me what we're going slow, or you know what I'm asking. I mean, what about it that kind of turned your attention to the car up front?
The vehicle up front was just the one that was driving slow. And driving slow could be a sign of somebody who is impaired, who is not able to visually observe the roadway correctly. It just caught my attention at that point.
So Trooper, you stopped Mr. Reed for driving too slow.
Yes.
35 and a 50.
Approximately, yes.
Okay. Was that based on visual estimate?
Yes.
Not radar?
No.
You were sort of, I didn't hear the exact numbers that you used in terms of where you were in line, third or fourth in line behind the vehicle.
When I reviewed bodycam, I believe I was the 5th, could have been the 4th, but exactly in the line, I couldn't know. I knew that there was probably another 3 to 4 behind me as well.
You had dash cam operating during at least part of this contact, correct?
The last portion of it, yes.
Okay. Have you reviewed that?
The dash cam, yes.
Okay. I want to show that to you. We're going to try this again. Hopefully I can be quicker. Trooper Lamro, right at the end there, it was kind of hard to see, but was that the vehicle that was stopped? Was that the blue F-150?
Yes.
Okay. Some questions for you about that. Did you see about the number of cars between you and the blue F-150 when you initiated the stop?
3 to 4.
Okay.
Roughly.
Did you observe the vehicle that was immediately in front of you start to move over even before you activated your emergency lights?
Yeah. So okay. I can explain that if you'd like.
And I guess just to describe the road there, at that point in time, it becomes a 2-lane highway in each direction.
Yes.
Okay. That car moved over to the right. The car immediately in front of you, right?
Yes.
Okay. And it looks like actually the car right in front of him did the same thing.
Yes, they all did.
They all did. But this was before you turned on your emergency lights.
Correct.
Okay. So these several cars move over to the right. And hard to see, but it looks like Mr. Reed did that as well, moved over to the right-hand lane.
He did at that point, yes.
All right. Other observations from there, we can see water on your windshield. So it had been raining.
Yes, I believe so.
Okay. And it speaks for itself. It was relatively dark at that point.
Yes.
Dark enough for all vehicles to need to have their headlights on and so forth.
Yes.
Okay. Now, the particular statute that we're dealing with here, are you familiar with that statute in terms of driving too slow?
Not right at the moment, no.
The reason for this entire stop was driving too slow, and the trooper on the stand just admitted he does not know what that law actually says. Here is what it says. It is illegal to drive so slowly that you block normal traffic, except when a reduced speed is necessary for safe operation. Necessary for safety. It was raining, the roads were wet, it was dark enough that every car needed headlights. A slower speed was not a violation. It was exactly what the law allows. They stopped a careful man for following the rule they could not even quote.
Are you familiar with any exceptions or maybe caveats to the idea of driving too slow?
I'd say weather, traffic, road condition, anything that would be of that nature.
Okay. What about, I mean, maybe this language is familiar to you and tell me if it is, except when a reduced speed is necessary for safe operation of such vehicle or in compliance with the law.
That would fit, yes.
Okay. Are there circumstances in which, are you familiar with a statute referring to too fast for conditions?
Yes.
Okay.
Fairly.
And that has to do not so much with speed limits, but what the conditions are and what a safe speed would be given those conditions. Is that fair to say?
Yeah.
Okay. And so can you admit of the idea that at times and under certain circumstances, it makes sense to drive below the posted speed limit?
It would, yes.
Okay. I don't have any further questions.
Do you solemnly swear or affirm under penalty of perjury the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
All right. Mr. Selleck, when you're ready.
Mr. Chilson, can you state your name and spell your last name for the record?
It's Jason Chilson. It's Chilson.
Mr. Chilson, how are you currently employed?
I'm currently employed as a private investigator, the director of investigations for a company called Pylon Defense.
Okay. I want to ask you a little bit more about your background. Can you tell us your relevant employment background as it concerns this hearing?
Yes. Initially, I was employed with the Aurora Police Department for just over 10 years until I left in good standing in November of 2018. I became certified in the use of SFSTs in the academy. They conducted a wet lab. That's where they bring people in and they drink to different levels of impairment. And you practice making correct arrest decisions based off your observations of their person. I have since participated in a total of 9 wet labs. I've actually ran a couple for the Aurora Police Department, and I've also participated in a green lab as part of the Understanding Legal Marijuana training, which is similar to a wet lab, but it's with marijuana. I've been to comprehensive DUI training, robust HGN training, advanced roadside and impaired driving enforcement training, drug ID and symptomology training. I co-founded the DUI unit for the city of Aurora along with 2 other officers. I was an operator and an instructor on both the I-5000 and I-9000 breath testing instruments. I went through the drug recognition expert program. I graduated top academic student. I've completed well over 1,200 DUI investigations that resulted in arrests. And as part of since I left Aurora, I had my own company for approximately 7 years before I went to work for Pylon. And as part of the normal course of business, I commonly review the ARIDE manual, SFST manual, DRE manual. And I've been qualified as an expert witness in court well over 90 times, approximately 30 to 35 related to cases involving allegations of intoxication, impairment, SFSTs, DUI investigations, things of that nature.
All right. At this point, I would tender Mr. Chilson as an expert in the areas of DUI investigation, standardized field sobriety tests, and police investigation.
Is there an objection?
No objection.
The court will recognize his expertise.
The man the defense just called as their expert is not on anyone's side but the truth's. 10 years at the Aurora Police Department. He co-founded their DUI unit. Over 1,200 DUI arrests of his own. A certified drug recognition expert. Qualified in Colorado courts more than 90 times. This is not someone who is against police. This is a man who spent a decade arresting drunk drivers. And now he is watching Trooper Corey's body cam frame by frame. When a man like this tells a judge the arrest was done wrong, it carries a weight the prosecution cannot answer.
Okay. Mr. Chilson, with regard to this case involving Mr. Reed, did you have the opportunity to review any of the discovery materials in this case?
I did, yes.
And can you kind of, in a general way, characterize what you were able to review?
Sure. There were several written reports, both from Trooper Corey and a written report from Trooper Lamro. I reviewed all the written reports that were provided to me. There were a series of body-worn cameras from both troopers, along with dash camera recordings from their vehicles, and I reviewed those as well.
In terms of reviewing the dash cam video, I think you said it was dark. Did you make any observations about what the weather was like?
Yeah, it was actively raining at the time.
Okay. And what were was the street dry? Was it wet?
The streets were wet.
Okay. And again, we're just on the subject of the stop here. Anything else stand out to you as far as relevant information with regard to the stop?
Yeah, the cars, once they came out of the circle, they moved to the right. It turns into 2 lanes on the north side. And that's started happening before the lights were activated, but there were no issues with the reaction to the emergency equipment or anything like that. But when considering speed limits and inclement weather, driving at 35 miles per hour is consistent with what the literature advises you should do in inclement weather. You should increase your follow distance and slow your speed.
The first part, except when a reduced speed is necessary for safe operation of such vehicle. I want to ask you, is the driver's age part of that consideration?
Yeah, everything would go into that. It would be the type of roadway surface, the driver's age, the lighting in the area, the weather, the visibility that they might have, the number of lanes, the room that they had on the roadway. And it's also something you'd want to talk to the driver about to kind of get their understanding of why they might have been driving that way. And that just wasn't done.
Given the conditions, which is to say it was dark, that it was raining, that the streets were wet, is it a criminal violation, in your opinion, to operate a vehicle at 35 miles per hour in a 45 mile an hour zone or even a 50 mile an hour zone?
Not in my opinion, no. And as the trooper said, I mean, he sees it all the time with semis. So it's done with regularity.
Before we get to standardized field sobriety tests, do you recall what Trooper Lamro and Trooper Corey stated about odor of alcohol and what that was?
Yeah, I believe Trooper Lamro classified it as a slight odor of alcohol coming from the vehicle. And Trooper Corey also documented it as the odor of alcohol coming from the vehicle, but neither trooper documented it as the odor of alcohol coming from his person or being associated with his breath.
So let's talk about that. When he's asked out of the vehicle, was there something there that could arguably be an indicia of intoxication?
Well, I think the trooper talked about it earlier, but he was using the car for balance. But if you listen to the conversation, he advised that he needed his cane. He has a cane that he normally uses. And so that's essentially why he was holding onto the car and was using that car for balance as he walked from the driver's seat all the way around to the back.
Okay. Now, Mr. Reed did acknowledge having consumed some alcohol that day, right?
That's correct.
Okay. But tell me if I'm wrong, consuming alcohol and then operating a motor vehicle in and of itself is not against the law, right?
Correct. Not, as long as it's not impairing you.
Okay. So what we're looking for is impairment. Was that what we're looking for?
That's correct.
So, Mr. Chilson, I want to ask you about the HGN and both the way it was administered and the clues to the extent that you could see them on body cam.
Yeah, and watching Trooper Corey's performance of the maneuver, you can see his left arm as he's conducting the HGN. And you can tell when he's checking Mr. Reed's, as he's facing him, he'd be checking his left eye. And as he's coming in front of the camera, he's not keeping the eye at distinct and sustained nystagmus from maximum deviation for the required amount of time to establish that or verify that as a clue. It needs to be done for a minimum of 4 seconds, and he's much closer to 2 seconds. And then for an onset of nystagmus prior to 45 degrees, as you're moving from center out, you need to, once you observe that onset angle, stop for a minimum of a second and verify that it's there. And you can see that he never does that. So you wouldn't be able to really count those sections as clues because you didn't perform it the right way and you didn't check for it. You didn't go for a minimum of 4 seconds. You never stopped to verify that that onset of nystagmus was actually there.
There it is. The one test this whole arrest depended on was done wrong. The manual says hold at maximum deviation for at least 4 seconds. The body cam shows 2. The manual says stop and verify the onset before 45 degrees. The trooper never stopped. Every shortcut he took turned a real clue into a meaningless one. He scored the man 6 out of 6. And an expert with 1,200 arrests just told the court not a single one of those clues counts. The trooper did not catch a drunk driver. He rushed the test and wrote down a perfect score.
In terms of, I mean, I know it's difficult to tell, maybe especially on this video, because it's not right up at Mr. Reed's face so that you can see his eyes, but were you able to make any relevant observation of Mr. Reed's eyes?
No, I couldn't really tell. Sometimes I can see the eyes good. This was a little dark, and with the reflection of the light, it was hard to tell.
Okay. Some questions about, I'm going backwards here a little bit. These road signs, they're supposed to be voluntary, right?
That's correct.
Okay. In your observation, did Trooper Corey, beyond saying that the road signs are voluntary, did he explain any of what that meant to Mr. Reed? When you're conducting it on a consensual basis like that, as an officer, you're required to take the extra step and not only explain that they're voluntary, but you have to explain that the subject has the right to refuse or doesn't have to do them if they don't want to, is the way I would always word it. And so you're required to take that extra step in a case like this, and that did not happen.
Cross-examination for this witness.
No questions, Judge.
All right, thank you. May the witness be excused.
Yes.
All right, you're free to go or stay as you wish.
Thank you, Your Honor. I appreciate it.
Thank you. All right, at this point, the evidence and testimony in this hearing is closed. Mr. Selleck, it's your motion.
Just very briefly, Judge, 2 issues raised in the motion. The first being reasonable suspicion to conduct a traffic stop. Probably an unusual issue for the court, and a law that doesn't really provide a lot of bright lines in terms of what constitutes a violation and what doesn't. My argument to the court is simply that it was dark, that it wasn't just raining, but the streets were also wet. to a degree that exercising caution under those circumstances was warranted. To me, there was no reasonable suspicion, or to anyone, there was no reasonable suspicion to conduct this traffic stop. Then we get to the issue of probable cause to invoke express consent and to arrest. So on that issue, basically all we have is what's documented as a faint odor of alcohol coming from the vehicle. It wasn't separately documented as coming from Mr. Reed's breath. We have probably most notably one of a normal battery of 3 tests in terms of standardized field sobriety tests. And the testimony from Trooper Corey is that we had 6 out of 6 clues. Mr. Chilson was able to observe to a meaningful degree how those maneuvers were administered, and the court heard his testimony. This maneuver needs to be done precisely right in order to get to the point of documenting all 6 clues. The uncontroverted testimony of Mr. Chilson is that there's no way he could have arrived at that conclusion of all 6 clues because he didn't administer the test correctly. It's impossible for the court to make a finding that there was probable cause to invoke express consent if the administration of the HGN was not valid. And again, the testimony is uncontroverted that it was not conducted appropriately in this case. It's the only roadside that was conducted. What we have left is a faint odor of alcohol, using the vehicle for balance. But again, that's attributable to the driver's age, I think even by Trooper Corey's admission. So we just simply don't have enough information to conclude that there was probable cause to require Mr. Reed to take a test. What we would be asking for as the result of both of these constitutional violations would be the suppression chiefly of the breath result, which was a 0.073. But of course, any other observations that occurred after the stop. So that's my argument.
Thank you. I would like to be able to review the exhibits again. And so we're going to need to set this over for receipt of ruling because we're going to run out of time here. And finding a time to set it for receipt of ruling is going to take time also. It's not the substance. I'm not hearing any additional argument. I just want to have an opportunity to look more closely at those videos. In 25T664, Mr. Reed appears in person with Mr. Selleck. We have Mr. Tommy here for the people. Do you want the hearing device?
Hey, Chuck, can I get you the hearing device?
I think I can.
You don't? Yes or no?
No, I think
Okay.
You're okay today? Okay. All right. We are scheduled for receipt of report on a motions hearing that was conducted June 24th. We had tried to do this last week. The court ran over and then there were conflicting schedules and the court then had a meeting. So we weren't able to get it accomplished last week, although I know that Mr. Reed was present, as was Mr. Tommy. You had been here and had to leave, et cetera. In any event, the motion before the court is on the defense filed motion to suppress evidence. They raised 2 issues of contention. The first being that there was not reasonable suspicion to conduct the traffic stop or otherwise detain Mr. Reed. The stated purpose by law enforcement was an allegation of traveling too slowly, and that's consistent with the 42-4-1103, driving too slowly, Class A traffic infraction for which Mr. Reed has been charged. The statutory language states no person shall drive a motor vehicle on any highway at such a slow speed as to impede or block the normal and reasonable forward movement of traffic, except when a reduced speed is necessary for safe operation of such vehicle or in compliance with the law. The court, one of the reasons that we set the matter over for receipt of ruling, or that the court set it over for receipt of ruling, was to more closely observe this video, whether the people would be able to prove this charge beyond a reasonable doubt, this court can't say. The officer has to go on the totality of the circumstances that he has at the time, which was driving behind Mr. Reed for approximately 3 miles, the line of cars that he was in, and experienced the consistently slow speed that he testified was lower than what was necessary under the circumstances, and taking into consideration the weather. The court notes that his suspicion under those circumstances was reasonable. Again, that does not mean proof beyond a reasonable doubt. So as it relates to the objection to reasonable suspicion, the court finds that there was reasonable suspicion sufficient to justify the traffic stop. The second contention raised by the defense was that Mr. Reed was searched, arrested, and required to submit to chemical testing without probable cause. Or the court did take the opportunity to more closely observe the dash camera footage and observed Mr. Reed continuing to drive. He pulled onto the shoulder area of the highway, but continued to drive along that shoulder for approximately 15 to 20 seconds before coming to a complete stop. The testimony of the officer relating to a faint odor of alcohol, it wasn't clear whether that was coming from his breath, his person, the vehicle. And then there was an admission to consuming alcohol. There was testimony, and the court was able to observe some of that on the video, stating 2, 3, maybe 4 beers since 2 o'clock. The court notes that this was at approximately 5 p.m. or slightly thereafter, and that he at some point had been at a restaurant, so consuming food with that. I do also note that Mr. Reed did appear to understand all of the questions and the instructions that either were asked of him or instructions provided to him. This information cuts somewhat both ways in terms of him being able to clearly and rationally follow instructions and to consider the questions being asked by law enforcement, but also in relation to his ability to voluntarily participate in what he was being asked to do. The court also presented evidence from their defense expert who testified in relation to, among other things, the sufficiency of the horizontal gaze nystagmus test as it was performed. But for example, that he was not holding the eye at distinct and sustained, to observe distinct and sustained nystagmus at maximum deviation to establish whether or not it existed, that it was supposed to be held for a minimum of 4 seconds. And as was observed on that video, he held it for much closer to 2 seconds. When testing for the onset of nystagmus prior to 45 degrees, once you see the onset of nystagmus, you must stop for a minimum of 1 second to confirm that you are in fact seeing nystagmus, and that did not occur in the administration of the test here. The court, in reviewing that portion of the body camera, concurs with the timing, as was testified to by Mr. Chilson, that again, when maximum deviation was supposed to be established, that it was not held for a minimum of 4 seconds, and was a much shorter period of time, not held for a requisite time, diminishes the reliability of the test. That when searching for the onset prior to 45 degrees, the position was not held. And so again, diminishing the reliability and the authenticity of the results. So the court looks at the horizontal gaze nystagmus with skepticism in this particular case, as not being performed according to the standard, and therefore the reliability of those results is called into question. There was an administration of the portable breath test in this case, and the defense does contest the language used in relation to the test. 6I1, which discusses what's required as a condition precedent to offering or in conjunction with offering a preliminary breath test. It states, following the lawful contact with a person who has been driving a motor vehicle or vehicle, and when a law enforcement officer reasonably suspects that a person was driving a motor vehicle or vehicle while under the influence of or while impaired by alcohol, the law enforcement officer may conduct a preliminary screening test using a device approved by the executive director, yada, 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 after first advising the driver that the driver may either refuse or agree to provide a sample of the driver's breath for such preliminary test, except that if they're under 21 years of age, which is not relevant here. So in Roman numeral 1 is where it discusses that the law enforcement officer must first advise the driver that the driver may either refuse or agree to provide a sample of the driver's breath for such preliminary test. In reviewing the body camera footage that was provided to the court, the statement made by the trooper was, "Can I offer you a portable breath test? It makes sure I know you are safe to drive home." That's the only statement that the court has in relation to the provisioning of the portable breath test. And while the statute is silent as to any specific language, the court can't go so far as to say that Mr. Reed was informed, or as the law states, advised of his right either to refuse or agree to provide that sample for the preliminary test. While he asked it as a question, "Can I offer you the portable breath test?" he does not inform Mr. Reed that he may either agree or disagree and either perform the test or refuse to perform the test. The statute is silent as to how the court should consider a failure to properly advise the defendant, although the court notes again that it says that that must happen prior to administering the test. The court makes the inference that if that does not occur, the legislature is indicating that the preliminary breath test cannot be performed. And so the court doesn't consider the results of the preliminary breath test in making a determination for probable cause. There is relatively scant information to support the probable cause or the determination to invoke express consent, that probable cause for that invocation. And the court notes that the law does not prohibit individuals from consuming alcohol prior to driving. It prohibits individuals for consuming an amount of alcohol sufficient to render them either impaired to the slightest degree or under the influence. And when we're talking about impairment, which is what Mr. Reed has been charged with, it's impaired to the slightest degree such that they are unable physically or mentally, or both mentally and physically to exercise due care in the safe operation of a vehicle. What the court sees is perhaps an excess of due care in this case and not the lack of due care. The court attributes that to the court to a certain extent attributes that to the weather and Mr. Reed's age, as well as the lighting conditions, noting that it's evening. The court doesn't find that there's sufficient probable cause to have invoked express consent. But the court doesn't believe that there was sufficient probable cause to invoke express consent. And so the court would grant the motion to suppress in relation to the requesting or the invocation of express consent and the results of said test. Do you want to chat right now? We're otherwise set for the pretrial readiness conference. So
yeah, if we could chat a minute.
I'll stay here.
Thank you. I'm going to borrow Mr. Reed here for a second.
Okay.
Hey, Chuck, can you come back and talk to me for a moment so I can explain what Mr. Tommy and I are talking about?
Now, what was the statute on the slow moving again, Judge? Yeah.
It is 4241103.
1103.
Judge, I think we have an agreement, Mr. Reed's case. The agreement would be for, and we don't have paperwork, but we're hoping the court will accept the plea on the record. It would be a plea to, I believe the driving too slow count is count 1, if memory serves. And it would be an agreement for $100 fine. Dismiss.
It's count 2.
Okay.
It has a standard fine of $50.
Oh, okay.
Okay, $50 is fine, Judge.
Okay. All right. And Mr. Reed, do you understand that?
Want to check it?
Or if you want to just pull the microphone, you can stay seated.
Okay. We can bring the microphone closer to you. So what the judge asked is, what you can sit down, Chuck, if you'd like. What the judge asked is, do you understand that you'd be pleading guilty to the charge we talked about, which was driving too slow?
Yes.
And did you understand that it carries a $50 fine and it's a 3 points against your license?
Okay.
Okay. Is that still acceptable?
Yes.
Okay.
Is anybody forcing you to do this?
She's asking, is anybody forcing you to make this decision? Like I just
No,
told you,
no.
you can still go to trial if you want, but this is how you want to resolve your case.
Yeah.
Is that a yes?
Yes.
Okay.
Now, are you under the influence of drugs, alcohol, or prescriptions that affect your judgment?
Are you under the influence of any medications that are affecting your decision making?
No, not at all.
Do you understand you have that right to go to trial? We're set for that trial on Thursday, but by entering this plea, you're giving up those rights to go to trial.
So you still have the opportunity to go to trial on Thursday if you want, but
You said no.
well, and I think you did as well, right?
Yeah,
it has to be your decision, right?
Yes.
I just give you the advice.
Yes.
So she's asking, do you understand you still have the right to go to trial, but instead of doing that, you're choosing to resolve the case with this plea?
Yes.
Okay. Is that how you want to proceed, is to move forward with the plea?
Sure.
Okay.
All right. Is there a factual basis for the plea?
There is, Your Honor, and the people would stipulate to that.
We had a motions hearing, Judge.
The court did observe the body camera footage and already made a ruling on the reasonable suspicion, at least. And to the extent applicable, has Mr. Reed been fully advised of any potential immigration consequences?
Yes.
Mr. Reed, do you have questions for me or for your attorney before I ask you how you plead?
No. Question?
Okay.
No.
How do you plead to count 2, driving too slowly?
Guilty.
I'll accept your plea. I find that it is knowing and voluntary, not the result of any undue influence, coercion, or force. You understand the rights that you have that you're giving up, and there is a factual basis. I'll note the motions hearing that we just held as the prima facie inability to prove count 1 beyond a reasonable doubt at trial, sufficient for the dismissal of that. Is there anything further for the people?
Nothing else from the people, Judge.
Any sentencing comments from the defense?
I don't think so, Judge. Again, we had the motions hearing. I think the court's fully aware of mitigating circumstances here as well. So
Anything that you want to say?
anything that you would like to tell the court?
No, I can't think of anything right now.
Okay. It's a $50 fine plus court costs and surcharges. There's no restitution. The remaining count is dismissed and the jury trial is vacated.
Suppress granted. The breath test thrown out. The DUI dismissed. Think about what actually happened here. An old man drove carefully through the rain on a dark, wet road. A trooper decided that was suspicious. He pulled him out of his car and ran the one test, the test that lives or dies on the officer's own word. He rushed it. He scored it perfect. And he arrested a man whose only real offense was being too careful to drive fast. It took an expert with 1,200 arrests to say what the body cam already showed. The test was never done right. And it took a judge to say the thing that should follow every honest look at this case. She did not see a lack of care. She saw an excess of it. The trooper was so sure he had a drunk driver that he never stopped to ask if he had done his own job correctly. He had not. And a careful old man walked out of that courtroom with a $50 ticket instead of a criminal record because his lawyer checked the tape the trooper forgot was rolling.